Welcome to Alabama Justice Lawyering Up. My name is Richard Jaffe, the senior partner in the Birmingham, Alabama law firm of Jaffe, Hanle, Whisonant, and Knight. We are going to explore with you the hottest cases, the most controversial topics of Alabama justice, and we're going to bring to you exciting key players that make our Alabama justice work or not work. We look forward to having you. Welcome to another exciting show of Alabama Justice. I'm Richard Jaffe from the law firm of Jaffe, Hanle, Whisonant, and Knight. And with me is my special guest, Kevin Butler, the federal defender. Welcome, Kevin.
Well, welcome.
And thank you for being here.
It's my pleasure.
Let's talk a little bit about what a federal defender is and a little bit about the history of you and your program in any order you'd like.
Okay. Well, what a federal public defender is and my office is, we are the institution, the entity, which represents the majority of individuals charged with federal criminal offenses here in the Northern District of Alabama. The vast majority of individuals who are charged in federal court are indigent. When they come into court, they're entitled to counsel, and my office and the lawyers that work for me are appointed to represent them. There's also a CJA panel, which represents approximately 25% of those individuals who come into court. But the majority of the individuals that are represented in federal court are represented by my office. By way of a little history, this is the last district in the country. There are 91 federal districts. We are the last district to establish a federal public defender office. There are like 3 remaining districts without one. I think the Southern District of Georgia and a territory or something to that effect. But prior to 2011, this office was represented solely by the CJA panel. That is a group of lawyers who are qualified to practice in federal criminal law in federal court. We were established in 2010. I was sworn in 2011, and we've been representing indigent persons charged with federal criminal offenses since 2011. The reason behind the establishment of the office, I can't speak directly to because I'm not one of the judges who were part of that discussion. But what I can say is the benefit, in my opinion, of a federal public defender office is you have a centralized repository of knowledge related to federal criminal law. Federal criminal law, I'd say, over the last 25 years has become extremely complicated. There's the federal sentencing guidelines, mandatory minimum sentences are in effect. It's become very complicated. By having a federal public defender office, you have a collection of individuals, quality lawyers, very highly qualified lawyers, who specialize in this new, highly complex area of litigation. The panel lawyers in this district are outstanding, but I think having a group of lawyers, my office, who are completely dedicated to federal criminal law and can provide the panel with some education, CLEs, and or assistance when necessary, I think benefits the community greatly.
So would it be fair to say that one difference between a private lawyer that's either retained or on the criminal justice panel and a lawyer in your office is that the lawyers in your office do nothing but federal litigation?
That is all. Federal criminal litigation, that is all we do. Mm-hmm. That's all we know. There's a joke my mom kind of lays on me every Christmas. You know, I had an issue regarding a contract, but I knew I couldn't call you because you don't know anything about that. And she's kind of right.
My mother said the exact same thing to me. Exactly. She wanted to know who was going to come to me
exactly
when I went into private practice. I said, well, We'll see.
Gotcha. But yeah, all I know, all I've practiced for the last 25 years is federal criminal law. So,
And that started in, well, not actually in Montgomery, but you landed in Montgomery before you came to Birmingham.
that's correct.
But you were somewhere else before Montgomery.
Yeah, I was assistant federal defender in both Nevada and Sacramento before I came to Montgomery. And that's where I was before I then came to Birmingham.
Where it was a very competitive position, and you were chosen by a panel of judges and others.
That's correct. The federal public defender position in this district, and I think every district, is selected by the circuit court. So the judges of the circuit, the chief judge, for instance, is Judge Carnes, and his colleagues, they interviewed me, and after that interview, I was honored to be selected. But that was a bit of a nerve-wracking experience, being interviewed by all of the judges of the circuit. But they were all kind, and it apparently went well. But
And you know it went well because you were actually renewed. When was that? A few years ago.
I was renewed in 2015,
Yeah.
so I'm in my second term. My term lasts for 4 years. After about 2 years into my term, the court basically sends out questionnaires asking the bar, the judges, how am I doing? And if I do well, that information comes back to the court and my term can be renewed.
How many lawyers do you have in your office?
Right now we have 12 lawyers, 10, excuse me, I take that back. Right now we have 10 lawyers, 8 assistant federal defenders, including myself, and 2 research and writing attorneys. The research and writing attorneys essentially provide just that, research and writing for our trial cases as well as our appellate cases. The 8 assistant federal defenders, including myself, we provide the actual trial representation, trial and appellate representation of individuals charged with criminal offenses.
When you say including yourself, of course, you are the federal defender.
That's correct.
So you are saddled with the leadership and organizational and management. You're the boss, but you're also doing some trial work as well.
Absolutely. One, that's what I love to do.
Right.
I'm a trial lawyer, and I love to get into court and represent individuals who are charged with offenses. That said and done, like you said, I can't have a completely full caseload because I have a lot of management responsibilities, ranging from making sure that we have adequate pencils and papers to making sure that our rent and bills are paid.
And hiring and firing.
And hiring and firing.
Let's talk a little bit about the increase in federal crimes. When you started practicing, and when I started practicing, I think there were like 1,500, 2,000 federal crimes. How many federal crimes are there today where someone could be charged?
Oh my goodness. I couldn't, at least 2,000 to 3,000. I mean, 1,500 to 2,000 back in maybe 92.
Yeah.
Maybe 2,000 to 3,000 now. There has been an increase in the amount of offenses which can be charged criminally. What I have seen over the last, what I'll say, 15 years of my practice is a dramatic increase in firearms cases. That is where the vast majority of our caseload lies.
And the penalties are significantly, as they should be, are increased for certain firearm cases.
That's true. Based upon the nature of the firearm and the person's criminal history, the person can be a person charged with a federal felon in possession of a firearm, and that's the offense that I speak to, that we receive the most often. But if the person has a substantial criminal history, crimes of violence, drug offenses, the person could be looking at a mandatory 15 years in jail at a minimum. But there has been a dramatic increase in firearm offenses. When I first started practicing in the 1990s, 1992 to around 2000, the majority of my caseload was narcotics cases, specifically crack cocaine. That was the focus of federal prosecution. It is my understanding that given what's been in the news a lot, the opioid crisis. We are anticipating a tremendous increase in opioid prosecutions, that is distribution of heroin. But those prosecutions are going to range everywhere from, for lack of a better word, the street level dealer who is selling, all the way up to doctors and or pharmacies or companies that are the government believes is criminally engaging in the distribution of these opioids. So we're anticipating a very large increase in those prosecutions over the next couple of years. As a result, you mentioned how many lawyers we have. The circuit has been, as a result of that, as well as just a general increase in our caseload, we anticipate going up to 12 lawyers. So we're at 10 lawyers right now. I anticipate by the end of 2018 having 12 lawyers in my office to help accommodate this increased caseload.
Let's talk a little bit about the federal sentencing guidelines.
Yes.
We hear about them a lot, but what are they really? And how are they applied?
Okay. The easiest way to kind of view the federal sentencing guidelines are they are a system of rules and procedures that Congress wants the courts, the judges, to follow in imposing sentences for individuals. Prior to, my dates right,
1987?
I'm about to say, prior to 1987, the federal sentencing guidelines didn't exist. What essentially happened in those circumstances was the judge received information regarding the individual who has been convicted of this offense, and that judge imposed, based upon information he received from possibly probation and some background information, what he or she, the judge, believed was the appropriate sentence. There were studies done showing that that was leading to desperate sentences, widely varying sentences. Judge X in a district in, I'm just throwing this out by hypothetical, Georgia, might be imposing a 2-year sentence for a certain offense. Judge Y in, let's say, New York was imposing a 5-year sentence for the same offense. So there were varying sentencing ranges for the same offense conduct and for people who were similarly situated, who were had similar backgrounds. The guidelines was designed to eliminate those discrepancies, to try to impose sentences that fell within a range so that a person who was charged with offense would have a sense of what he or she was looking at, and that the sentence that that person was looking at would be the same as another person in another district.
So for a while, those guidelines were pretty much mandatory in terms of the way they were applied, but over the last 7 or 8 years, they're now more advisory.
Right. The problem with, it's a very complicated legal issue, but you're absolutely right. Once the guidelines went into effect, they were mandatory. The court had to oppose a sentence based upon the sentencing range that came out of this book. The Supreme Court, without getting into the details of the decision in a case called Booker, basically said the guidelines have to be advisory. If they're not advisory, it runs into constitutional problems.
And with that latest turn we just discussed, that allows the judges to both consider the guidelines, but also the individual they are sentencing a little more carefully.
Perfectly said. And as a criminal defense lawyer, it allowed me, as a criminal defense lawyer, you, and my office to be advocates again. I can't count the times when the guidelines were advisory that we would make compelling arguments to a court, and the court would say, you know, I find that very compelling, I find your arguments very persuasive, but I have no choice but to impose a sentence between here and here. Now I can go into court and make those compelling arguments, and the court says, you know what, I'm not going to impose a sentence between here and here. This is a circumstance where I can go down. The flip side of that, the government can come in and say, Your Honor, well, this is a circumstance where this is the range, but I think you should go up. The fact remains, though, that we can now be advocates again, zealous advocates for our clients, and
At the sentencing phase.
At the sentencing phase,
Right.
and hopefully convince the court to impose a sentence below what had traditionally been a mandatory sentencing range.
So in essence, if we're really doing our jobs as criminal defense lawyers, we want a sentencing hearing to allow the judge to understand everything about our client so they can apply the guidelines in a way that is fair.
Absolutely. One thing that kind of common sense will tell you is the majority of individuals who are charged with offenses resolve their case by way of plea. I'm not going to get into the reasons why or why that happens, but the vast majority of cases resolve themselves by way of plea. Because the vast majority of cases resolve themselves by way of plea of guilty, it's imperative on the defense lawyer to get information related to the client's background, his history and characteristics, so that the court can impose a meaningful sentence, and the court just doesn't see a John Doe who is convicted of X and therefore just must get a certain sentence. Because the advisory guidelines are still in effect. The court still has to look at them. And if the court just sees a John Doe who's charged with offense X, the court, understandably, because it doesn't have adequate information, will tend to impose a sentence within that range. The quality defense, if you receive a quality defense, if your lawyer does a good job, and I think our lawyers do,
we get question.
Appreciate it. We get information before the court, which allows the court to say, no, I'm not going to impose a sentence between this range. I'm going to go down.
Wonderful. That's an extremely informative discussion. We'll be right back with our special guest, the federal defender, Kevin Butler. My name is Richard Jaffe of the law firm of Jaffe, Hanle, Whisonant, and Knight, Birmingham, Alabama. With me is one of my partners, Brett Knight, and I'm going to ask Mr. Knight a question about how you can protect your record if you're arrested and ultimately win your case. Brett, tell the audience what an expungement is.
So an expungement is basically you're filing a petition with the court where you have actually been arrested, and there are certain requirements that have to be in place, but if you are successful in the petition, you will have your arrest and the charge expunged, sealed from your record. This can be beneficial for both employment and school purposes. Now, not everybody is eligible for an expungement. Most misdemeanors, almost all misdemeanors are. Some felonies can't have an act of violence involved in them, but it can be very beneficial for anybody to actually go through this process. And